Court is calling 2024 CR 010117, State versus Erik Kelly. Can I have parties approach and announce for the record for the state? For the defense?
Robert Bears on behalf of the office of Kelly Green.
All right, and are you Mr. Kelly?
Yes, ma'am.
All right, do you have any objections to Attorney Barron standing in for Attorney Kelly?
No, ma'am.
Right. And I'll note for the record that the court is in receipt of the discovery acknowledgement. Counsel, have you received all of the discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. And count two, the charge is aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand? Mr. Kelly, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
That's correct.
Court will find, yes or no?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count two. They're asking that your punishment be assessed at 2 years in the prison. Do you understand that if I find a deadly weapon was used, there will be an affirmative finding of deadly weapon?
Yes, ma'am.
And there are no applications. This is to run concurrent with County Court Cause number 708-473, 709-900. State will take in consideration 2024 CR 0497 and 2024 CR 5344. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Then to the offense in count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states exhibit number 1 and attachments.
There's no objection.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so does anyone want to explain why the court should go forward with this agreement?
Judge, I'm not familiar with the facts of this case.
Okay, sure.
Judge Jason Garaham for the state.
Yes.
And Judge, in this particular case, I'm sorry, I just came in right now from out of court.
Mhm.
My question, I think your question was of why you should proceed with this,
Yes.
is that we've talked to the victim in this case, and we feel that this is an appropriate outcome in this case.
All right. So you've spoken with the complainant and they're aware of this outcome and they're in agreement with this outcome?
Yes.
All right, thank you.
Judge, just so you know as well, Mr. Kelly has been suffering from a lymphoma since he was a child, about 10. He's had a couple occurrences of it, and apparently it's rearing its head again. He has a lymph node in his eye that is significantly swollen or tumor-like, and probably going to need attention on that while he's in custody.
All right, court is finding you guilty. Court will sentence you to 2 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. This is run concurrent with County Court Cause number 708-473, 709-900. Take in consideration 2024 CR 0497 and 2024 CR 5344. And there is to be no contact with the following. The first is the street location of Gateshead Road, Gateshead Road. That's San Antonio, Texas, 78251. And there's to be no contact with the following persons. Ryan Dekrone, Dekrone. Tamara Scrum. Marissa Magana, Magana. Anything?
Marissa Magana, she's not a complainant in this case. That's Mr. Kelly's girlfriend. fiance.
She's the co-defendant. Are you all married?
Yes, ma'am.
When were you all married?
We haven't finished the paperwork, but she's got issues.
As far as I know, and I've checked the record just this morning, she was never a co-defendant in this case.
No, they have her,
Defending a fraudulent use or possession of ID case.
no, they have her listed as defendant number 2 in the,
They never
Paperwork.
charged her.
She haven't done it.
That's correct, Your Honor. I don't think she was ever indicted under this case. I mean, it is listed as like a suspect. I mean, not a suspect, like, as a co-defendant.
they said that suspect 2, which is her, was also found to be armed.
That I don't think they even ever charged her with it. They did charge her with fraudulent use or possession of ID stuff.
All right, while they look for that, there should be also no contact with Desiree Johnson. Itzzel Lugo. Prudencio Benavides. Raymond Rangel. Norma Villarreal. Yes.
Okay, okay.
Yes.
Sorry. Judge, that case was sent over as a ag robbery, but it was rejected for further investigation. That's the extent of it. Usually further investigation means possibly insufficient evidence on her. But as far as I know, it's been rejected at a intake level by the DA's office.
All right. Then I'll remove that as a part of the sentence. All right, so we're off the record. You have all these health conditions. You need to start making better decisions with your life. You understand?
Correct.
I'm going to tell you what I tell everybody else. We could not have funding for water or whatever it may be. They will always, and when I say they, the government will always find room to fit people at the Bexar County Jail and to fit people at the prison. There's always room at the prison.
For the cancer treatment as well.
What I'll do is I'll put on their therapeutic community, but you need to let them know that you have medical issues. They usually will have a medical clearance for you before you go. And so they'll see if there are some issues. All right.
Yes, sir.
All right. Good luck to you. And Deputy Laura, can you make sure when he's sent over that they notate that he has some medical issues? Thank you. I'm telling you, the people with the coughs, are you guys going to be okay? I'm concerned.
It just won't go away.
Court is calling 2024 CR 3950 State versus Trevor Morse. Could I have parties approach and announce for the record for the state? For the defense?
Rene Munoz.
And are you Mr. Morse?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Probation, there are no applications. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right. All right, you're charged with unlawful possession of a firearm by a felon as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Mr. Morris, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
According to the plea, punishment is to be assessed at 7 years in the prison. There's a $2,000 fine, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is correct, Judge.
State, is that the plea?
It is, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State, any evidence?
State offers states exhibit number 1 and attachment.
No objection.
All right, state, you may be excused. All right, off the record for a moment. State, yes. So with regards to the indictment, are you all still proceeding on the indictment as presented or state you're asking to amend?
Your Honor, the state moves to amend the indictment.
Any objections?
There's no objection from the defense, Judge.
All right, Mr. Morris, do you understand that that's a substantial change to the indictment and a substantive change to the indictment?
I don't really understand what that means, no.
What it means is that because there's been a substantive change to the indictment, your attorney is entitled to 10 days to prepare for trial.
You understand?
Yes, ma'am, I understand.
All right, so do you wish to proceed or do you wish for your attorney to have more time to prepare?
Wish to proceed, ma'am.
All right. Then state you are, the court will grant without objections the state's request to amend the indictment. And the indictment is amended with regards to the cause number that makes your client a felon. And so the cause number that is listed in the indictment is 2018 CR 8895B. And that will be changed to 2017 CR 8895B. All right, then state you wish to offer into evidence the waiver and consent to stipulations of testimony and stipulations.
No
All right.
objection, Your Honor.
Court will accept into evidence states exhibits 1 and attachments and review the same. Oh, and state you may be excused. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor,
Anything you wish to say on behalf of your client?
we ask the court to respectfully follow the plea bargain agreements. In relation to my client's matters, we do feel like he has some mental health and substance issues that contributed to him being placed into the judicial system. We're asking for the courts to hopefully recommend a therapeutic community inside the institutional division judge. And with that being said, my client has learned from the mistakes that have led him to this point, and definitely going to use it as a learning experience, and with the goal to never re-enter the courtroom again on any future charges.
All right, then the court will follow your agreement. The court will find you guilty, sentence you to 7 years in the prison. There's a $2,000 fine, time and money to run concurrent, credit for any time served. There's to be no contact with Monica Yvette Vargas or the Gus Garcia Apartments, San Antonio, Texas 78207. And the court will recommend the therapeutic community. Therapeutic community doesn't increase the time that you're in custody, but it's hopefully to help you rehabilitate. Do you understand?
Yes.
I do not have the jurisdiction to force them to place you in the program, but on the judgment, they'll see that I'm requesting it for you. You still will not be considered if you do not request it yourself. Do you understand?
Yes.
And you should know by now, you are not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
All right, good luck to you.
Thank you,
welcome.
Your Honor. May I be excused?
Yes, thank you. Anzaldua? All right. Oops.
Sorry. Josh, come on up.
And is this a plea for 2 cases?
It
Two
is
cases, yes.
2 cases concurrent, state as opposed to probation, so I anticipate we will need a PSI date.
All right. Ms. Ferguson, I get a PSI date? And he's not in custody?
No, he's here, Judge.
Yes. Oh, so I can let them know.
Oh, yeah, sorry.
All right, March 20th is the earliest I can have you all in, unless you all, if the issue is one of a TAP evaluation needed to be done, counsel, then that will be quicker. And then I can reset it off in a couple of weeks. And you all can bring whatever witnesses you want to be brought in. Otherwise, I can have them do a full PSI.
I'm okay with the full PSI. My February, it's gonna be very trial heavy.
Okay.
I know I have 2 murders set, so it's
All right,
20th is probably a pretty good date.
Marma, you said March when? All right, so March 20th, Vashon will be for PSI and TAP evaluation. Is there to be a MIC evaluation as well or no, counsel?
I don't think there's we don't request one, Judge.
Okay. All right, we're going to go on the record. The court is calling 2024 CR 006 799 and 2024 CR 3794, State of Texas versus Joshua Anzaldua. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Adam LaHood, Your Honor.
And are you Mr. Anzaldua?
Your Honor.
And counsel, is there going to be an application for deferred in each cause?
Yes, Your Honor. I believe you have two in front of you.
All right. And Mr. Anzaldua, in each cause number, did you review the documents entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
And each cause number, and the cause number ending in 6799, you're charged with assault on a peace officer or judge. And cause number ending in 3794, you're charged with evading arrest, detention, vehicle with a repeater count. If the repeater count is proven, then your punishment will be assessed at a second-degree felony. Range of punishment in each of those cause numbers will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? In each cause number, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine. All right, off the record for a moment. On this one, do you all want to check that he's previously been convicted? And each cause number, did you review the plea bargain page? I'm sorry, off the record. Where do we stop?
Up to $10,000
Thank you. All right, we're back on.
I think
Yeah,
it was
we're
that.
back on the record. And each cause number, did you review the plea bargain page with your attorney? Did you understand it? All right, you're to agree that you've been previously convicted of one or more felonies for enhancement and the cause number ending in 3794. Punishment is to be assessed in each cause number at a cap of 10 years in the prison. All right, off the record for a minute.
Did we forget to?
It does say cap.
And then we
This doesn't-
opposed,
it
yeah,
does,
I meant to, we even talked about it. I just forgot to give it back to you.
Oh, no problem.
Thanks, bud.
Hey, it's Friday and it's a
Wait a
late
minute,
Friday.
It's not marked on either of them.
No, that's what I'm saying. I forgot to give
okay.
it to you.
Okey dokey.
We're good.
No problem.
Your initials on that one too.
Yeah, while we have it, so we submitted the app for deferred. I think that application covers both regular and deferred.
It does.
Yeah, some courts make you fill out both, which I never understood, because if you read it, it says in the event, yada, yada.
Mhm.
I don't know.
All right. So according to the plea bargain agreement, there's a cap of 10. The state is opposed to your applications for community supervision and opposed to your application for deferred adjudication. The cases will run concurrently, and the state will take in consideration 2024 CR 006796, 006798, and 007768. Did you understand that to be the plea? Defense is at the plea?
It is, Judge.
State is at the plea.
Yes, Your Honor.
All right, then in the cause number 2024 CR 006799, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause number 2024 CR 3794, how do you plead? Guilty, not guilty, or no contest?
No contest.
And to the enhancement, how do you plead? True or not true?
True.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And cause number 2024 CR 3794, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. And the court will review the stipulated evidence in 006799 for sufficiency. All right, and cause number 2024 CR 006799, court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Mr. Anzaldua will come back on March 20th. And at that time, I'll base my decision on your application based upon any evidence that's submitted to me. Probation will speak to you. Make sure you make all of your appointments. We're off the record. Sometimes when you see probation, you go for your first appointment and you think that's it. But you'll have other dates after that, and your attorney will speak to you about that, and probation will speak to you about that. Do you understand? So they're going to do the PSI and they're going to do the TAP evaluation. Do you have any questions? All right, once you sign the reset form, you'll be excused.
Thank you, Judge.
Thank you. Richard Ortiz. All right, are you all ready to proceed?
Yes, Your Honor, we have an agreement and PR,
All right, did you all do a
of course,
trial court certification?
now, but I will do that, Judge.
All right, thank you. And can I get a file stamp, please, for a motion to revoke? Oh, no problem. Thank you. I'm sorry, which one? Oh, let me just do this. All right, court is calling 2021 CR 5898, State of Texas versus Richard Ortiz Jr. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Michael DeLeon for Mr. Ortiz.
Are you Mr. Ortiz?
Yes.
Are you the same Richard Ortiz Jr. who was placed on deferred adjudication for the offense of possession of a controlled substance penalty group 1 to 4 grams on August 29, 2022 for a period of 2 years? Is that you?
Yes, yeah.
All right, state.
We wish to proceed on violation of condition number 1 on or about the 23rd day of November 2024 in Bear County, Texas. The defendant, Richard Ortiz Jr., committed the offense of possession of controlled substance and violation of condition number 1.
How do you plead to that? True or not true?
Sure.
Waive and abandon the remainders, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It is for the court to grant the state's motion, adjudicate the defendant guilty, revoke his community supervision, and sentence him to 3 years and TDC.
All right. So has he done anything on probation?
He's done a lot, Your Honor. He was successful in safety. Yeah, he's got 401 days of credit. He was doing wonderfully, Judge, until in November, there was a incident where he in a vehicle with another individual, where the police pulled him over and he was caught with one little, what was it? Less than a gram of meth, Your Honor.
See, here's the thing. You have to change people, places, and things.
Yes.
And anybody who is not helping you with your sobriety, then you got to cut them loose. All right.
Judge, additionally, he has tested clean 9 different times in a row. In 2024, he was doing pretty well overall, so we'd ask the court to go along with the plea recommendation.
All right. And did you turn over the,
I haven't, Judge, I
Oh, thank
didn't
you.
have the cause number in front of me.
oh, I'll put the.
Apologize.
All right. Are you asking the court to follow this agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, then the court will follow your agreement. The court will grant the motion. The court will find you guilty. Court will sentence you to 3 years in the prison. Give you credit for any time served, credit for any inpatient treatment in the therapeutic community. All right. Here's the thing. I wish, things would have been different for you. Although my grandmother always say, never use the word wish. I hoped that you would do better. You still have a chance to maintain your sobriety and get everything on track when you're released from custody. Immediately when you're released from custody, you need to find a sober support group so that you can stay on your mission. Because once people go to the jail or go to the prison, they say, when I get out of here, I'm going to do A, B, and C. But for you, you got to have a plan and you got to stick to it. When you're released, if you can't find a specific place to go, you can always come back here. If I'm still here, I'll help you find a place.
Thank you so much, Your Honor. I appreciate you.
All right, thank you. Have a great one.
You did.
All right, thank you. Marquise Bosier. All right, are you all ready to proceed on the motion to revoke?
Yes, Your Honor.
Court is calling 2022 CR 6099, State of Texas versus Marquise. How do you pronounce your last name?
Bosier?
Bosier. Could I have the parties announced for the record for the state?
Ashley Jones.
Defense?
Zachary Munoz.
And are you Marquise Tyree Bosier? Are you the same Marquise Tyree Bosier who was placed on deferred adjudication in 2022 CR 6099 on December 5th, 2022 for a period of 2 years for the offense of assault bodily injury? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, I'm sorry, give me just one minute. The state is proceeding on violation of condition number 4. Would you like me to read that?
Yes.
Violation of condition number 4 on the August 9th, 2024 supplement to the motion to enter adjudication of guilt. In Bexar County, Texas, the defendant Marquise Tyree Bosier, I'm sorry, did then and there fail to report to the supervision officer as directed for the months of April, August, December of 2023 and March 2024. Violation of condition.
How do you plead to that, true or not true?
And Your Honor, I do apologize. The state is going to waive that condition. I read the wrong condition.
Okay,
So the state will be proceeding on violation of condition number 14G. That on or about the 23rd day of April 2024 in Bexar County, Texas, the defendant Marquise Tyree Bosier did then and there fail to comply with the instructions of the Battering Intervention and Prevention Program, or BIP, as directed by the head or authorized personnel of that agency, in that the defendant did not provide proof of attendance in violation of condition number 14.
how do you plead to that, true or not true?
And the state will waive all remaining conditions in all supplements and original.
Any objection to the waivers?
No objection, Your Honor.
Did you understand by pleading true to violation 14G, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Knowing that, do you still wish to plead true to 14G? Court will find 14G true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That agreement is to grant the state's motion to enter adjudication of guilt, adjudicate the defendant guilty, and sentence him to 237 days in the Bexar County Jail. That would be a JSAT, and we would ask that time and money.
All right. What has he done on probation?
Your Honor, my understanding is he did complete some of the courses. He did pay some of the fines and fees.
Did he complete anything? Did he complete the batterers intervention program?
No, Your Honor, that's why he pled true to that one. He enrolled, unfortunately, as of course well aware, it's quite time consuming and it's quite expensive in my client. Unfortunately, he has a wife and stepchildren that he is the main financial provider. Unfortunately, his wife came down with an illness to where she was unable to work, so he was.
Is there any proof of that?
I don't have the proof for today, Your Honor.
Did he
But we
tell
are asking-
probation that he was having these issues?
I'm not aware if it's not notated in the.
Did you tell, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Marquise Bosier.
All right, did you tell probation you were having difficulties? Did you tell them about issues concerning, is this your wife?
Yes, ma'am.
Did you tell them about that?
No, ma'am.
Okay. Did you complete anything on probation?
I believe it was, I had 2 courses. The BIP was the only one that I didn't complete, but everything else I completed.
All right, so you completed the DOEP course? All right, the main course is the BIP, because that's the battery intervention course.
Yes, Your Honor. No, we understand, and that is why, you know, he has been in custody for 237 days. That's why we're asking. It's pled true to that violation. We're asking the court to accept that the current agreement of 237 days and hold that as a judgment satisfied for this case.
All right, and who is the,
The complainant is an ex-girlfriend from years ago, back in 2022 or earlier.
so has he had contact with her?
I've spoken with him prior, and no, he has not. He can go on the record, of course, and testify saying that as well.
And Your Honor, just to clarify for the record, I just want to make something correct for the record. At least in one of the supplementals, it does allege that there is a violation for not completing the supplemental, for not completing the drug course. That is an allegation that the state is waiving.
Okay.
But I just wanted to have that in front of you.
All right, the court is going to grant the motion, find you guilty, revoke. There's an affirmative finding of family violence. There's to be no contact with the complainant. That's Danesha Gray, Danesha. There's going to be credit for any time served. The court will sentence you to 1 year in the Bear County Jail. All right, good luck to you.
Thank you.
You're welcome.
Your Honor, if I can just explain to him what just
Sure.
occurred so you understand.
Yes. Who's here on Darin Johnson? All right, have you all conferred with Ms. Ferguson on a jury trial date?
We did not, Judge.
How long do y'all expect this trial to last?
3 days. Longest.
All right, Ms. Ferguson, I need a jury trial date on Johnson, Ms. Johnson. Because there was a snow day, we can't have your jury trial. Oh, I love the outfit you're wearing. You always dress appropriately for court. I appreciate it. So we're gonna do our best to get your jury trial date. So what date? April 1st. All right, so it's gonna be April 1st.
Thank you, Your Honor.
All right, thank you so much.
Thank you, Your Honor.
You're welcome. Once you sign the reset form, you're excused.
Thank you, ma'am.
Can we go on the record? That's
Sure.
fine. It's misremembering the conversation we had previously.
Oh, what, you want to go on the record with that?
Just
Attorney-client privilege.
yeah, you're right.
All right, let me see him. Could you come down, sir? Let me explain some things to you.
He's failing to understand the jail credit will essentially, if he's given 2 for 1.
So here's the thing. With motions to revoke, your attorney in the state, they may say, oh, we agree that this is what we want to happen. But because that is a contract with the court, it's not a contract with your attorney or the state, I don't have to follow any agreement that you have. With regards to credit for time served, legally, I'm bound to give you credit for any time that you've been in custody. So I sentence you to the maximum amount that's allowed, which is 1 year at the Bear County Jail. How much time does he have in?
238 days.
All right, you have 238 days in. What I can tell you is I'm not in charge of whether you receive 2 for 1 or 3 for 1. That's the jail. Normally, the jail will give people 2 for 1. So every day that you are in custody, you get credited for 2 days. Do you understand?
Yes, no.
All right. Do you have any other questions?
No.
Thank you, Your Honor.
Thank you.
Thank you.
You're welcome. Who's here on Dino Acosta? All right, good morning.
Morning, Judge.
All right, so is this a sentencing? What are we doing here?
It's a PSI, Your Honor. We had started it, but he was on Zoom because he works offshore
Yes.
and we decided to come in.
All right. Oh, I don't recognize you not in the little box. You know, sometimes I have to do this to people, then I'm like, oh, okay, I recognize you. All right, court is calling 2024 CR 007532, State versus Dino Acosta. Could I have parties announced for the record for the state,
Jason Garahan, Your Honor.
for the defense?
Brendan Lopez for Mr. Acosta.
And are you Mr. Acosta?
Yes, ma'am.
All right, we're here for sentencing. According to your plea bargain agreement, punishment is be assessed at 6 years in the prison. The state is opposed to your application. And there's to be restitution to the complainants. Have both parties had a chance to review the PSI report, state,
Yes, we have, Your Honor.
defense?
We have, Your Honor.
Any objections to the PSI report, state,
No, Your Honor.
defense?
No, Your Honor.
All right, state, you are opposed?
Judge, actually, we've talked to defense counsel. We were opposed, but we've made an I believe we're in agreement that the restitution amount is 16,500. They are not opposed to that and agree to that amount, and the state hence would not be opposed to an application.
All right, so when is your client planning to pay this 16,500?
Well, Your Honor, he works offshore right now, so he's making good money and his costs are lower because he gets to work offshore, even though he has family here in the valley. But I believe he can make substantial monthly payments. I don't know if he can come up with it all in bulk, but he can make substantial monthly payments, Your Honor.
All right, before, and this is, we can go off the record, this is just based upon my experience.
Yes, ma'am.
I will have people who have been on deferred adjudication and they never pay. And people want their restitution.
That's correct.
So what I am telling you is you need to pay half. You understand?
Yes, ma'am.
And then we'll have your sentencing. Okay, so will you be able to pay half?
I can, I want to say maybe in about a month.
All right, I'm
That's-
gonna give you better than that.
Okay.
We're gonna call this back for sentencing on April 1st. That will give you more than enough time. Don't come with excuses. You need to be prepared to pay half. And then that way, the other 8,000 that's owed, 8,500, it won't seem so daunting. And you can be on a payment plan for that.
Yes, ma'am.
But the key to this is the complainants want their restitution.
Yes, ma'am.
All right, Ms. Abrams, we're gonna bring this back on April 1st. And if he has paid that, counsel, then if the Zoom is working, we can do sentencing by Zoom.
Okay.
And what I will tell both parties, if he's paid that amount, I'll follow your new plea bargain agreement. And if you all could just write up a new plea bargain page, so that can be on the record and in the court's file.
Thank
All
you.
right?
Yes.
So yes,
If at all possible, if we can have him in person, if he's going to be probation.
all right. Are you able to be in person on April 1st?
I just got promoted to do overseas, going to the Dominican Republic, and it's gonna be 3 weeks on, 1 week off. So, I mean, it's just really up to the schedule that,
Well, I'll tell you what we'll do.
yes, ma'am.
We'll keep him for April 1st. We'll say it's in person.
Okay.
If for some reason you're still out of the country because you are completing work, we'll work around that.
Yes, ma'am.
All right, is everybody in agreement to work around that? Because,
Yes, ma'am.
all right.
Well,
So if you all will complete the plea bargain page, redo that. And if you can add to the plea, if you all want to add it to the plea, that 8,000 must be paid at the time of sentencing.
Is that, did you ask for a half, Judge, or just? Just
Oh, it's
8,000?
not really fast.
Just 8,000?
Just 8,000.
Okay.
So it will be $8,250, but if the 8,000 is paid, that will be good. Okay? All right, thank you.
Thank you, Your Honor.
You're welcome. John Thunert? Yes.
Before we, Mr. We have so I have a case set for Monday, and it's, the guy's name is.
It's a long week, we are trying to meet with our complainant to discuss a counter by them, which I think will resolve the case. She was supposed to come into our office on Tuesday. Was canceled, we weren't open, and so I'm just asking for another week.
Yeah,
We tried to reschedule her and we haven't been able to, but it's like critical that I go over what Mr. Calvers and I discussed.
And that was on Luis Alberto de Leon.
They-
Okay, and you already have someone set with us?
I have, what he said for Monday, but it was for our final pre-trial. And I think it's gonna get resolved. They just need to make sure that with their complainant that it's okay to do that. And so we're just trying to, I guess.
He's really accommodating me in my need to explain why we're doing what we're doing. And
All
so I just happened to be in here, so I said, if she calls you before she calls my case, can we both approach on that for Monday?
All right, I can set it for the 4th.
Thank you very much. And then
All right, could I have a reset form, please? Yeah.
Thank you, Judge.
You're welcome. Thank you for addressing it appropriately for court. We're going to bring you back at the request of the state in the defense for,
That's on him, Judge, I'm sorry.
oh, you're not Thunhart? Where's Thunhart?
This is Thurman, this is.
Yes.
So we're on De Leon for Monday. We just both happen to be in your court at the same
Okay,
time.
I don't have, did you all ask them to pull the
I
file?
didn't, yeah, so I know, I'm trying to break in all the rules.
Well, you all need to have that file pulled.
Okay, we'll do that.
Thank you.
All right, so this case, what is happening with Mr. Thunhart? Because he has a jury trial date.
He does, Judge, and I conferred and they've made an offer, and they're gonna look at some evidence to see if they will revise that offer, but we don't have an agreement yet. And so if the court, I'd request another trial setting, but I will obviously abide by whatever the court decides to do.
All right, the jury trial date on this case will be February 24th.
Thank you, Judge. Thank you, Judge.
All right, you're welcome. And once you sign the reset form, you'll be excused.
Thanks, ma'am. Sorry about that, Judge.
Oh, no problem.
No, you're good. I didn't.
If you'll just have them in the back to pull the file.
Yes, thank you. We're gonna get the cause.
All right, James Ross. All right, you've been appointed.
Yes, Judge.
And what I can do, I know you said you want a bond reduction.
Well, Judge, I guess my understanding is that you had remained with him without bond, and I did want to approach regarding the status of his bond. He was asking that it be reinstated.
Oh, the bond, you'll have to speak with the bondsman on whether or not the bondsman wants to reinstate.
And I
his-
did just get off the phone with Cowboy Bail Bonds,
Mhm.
and they were looking, I don't know if there's, she was not aware, the person I spoke to, was she looked through the notes of any affidavit to surrender.
Mhm.
And so they said they didn't have an issue with, because they still are on his bond, is my understanding. They had did a reinstatement back in December,
Yes, bond reinstated,
Right.
so it was recalled.
but they're not aware of any affidavit of surrender surety. I see that there was one that was.
All right, so you're saying he has a warrant out?
Well, my understanding is that he was here in court on the 13th and that he was late, and when he
Oh, yeah.
appeared that he had remained with him without bond, and so I didn't want to address that and ask.
All right, have you conferred with the state on that?
I have, Judge. I spoke with-
And actually, no, if I remember this correctly, the bondsman got off his bond.
I was just gonna interrupt you.
Yeah, the bondsman got off his
Okay,
bond.
and I did call them just right now, and they were looking through notes, and so they didn't see it. I need to, I guess, look at.
No, so the bondsman got off of your bond. So you probably want to tell them that's in the notes. That's why he was taking it. He came late. And I would have issued a bond forfeiture, but have attorneys on his late attorneys on his late arrival. But then before any of that was done,
Okay,
the bondsman filed a affidavit to surrender surety. So that's the bondsman who's not on your bond.
okay. Well, so I'll speak to them. I guess I need to check with the clerk's records because I did not, they were not aware of that when I spoke to them.
And so when would you like this recalled for you to review?
As soon as I can, I know that I'm gonna be in trial next week. Judge, he would like to address the court.
Yes.
Greetings, yeah.
Mhm.
I apologize for being late that day.
No. Here's the thing. We're past that point because the reason why you're in custody is not because you were late for court. The reason you're in custody is because your bondsman no longer wanted to be on your bond. And I saw it was in order. So I signed the affidavit to surrender surety. So that's why you're in custody.
Okay. All I've been able to see is that I've been remanded without bond. And
What I'm telling you is the bondsman got off your bond. So he'll need to, a new bond will have to be set if that's what your attorney wants. And we'll have to set that on a different day.
when I spoke to them as well, they told me that they were still on my bond. The reason that they told me also that they.
All right, so does anybody want to pull? I am telling you, my mind is a steel trap. And what I'm
understand.
telling you is your bondsman got off your bond. We can have it, here's the thing. I want you to understand something. We can continue to have this conversation, but it's not going to go anywhere. We're not going to finish the marathon. The reason why we're not going to finish the marathon is because what I'm telling you is the bondsman filed an affidavit to surrender surety. I know what they're saying. They told your attorney, but I'm telling you, that's the document I received. I signed it. So your bondsman may need to file an affidavit to restore the bond. I haven't received that. That's what your bondsman need to do. Okay? So that's where we are. No hard feelings about you showing up late for court, because guess what?
You'll never
We're
have
all,
me.
here's the thing, we're all adults. If people want to, if defendants want to stroll into this court at 11 or 10 or 9:05, they can. But there are consequences for that. You understand?
Yeah, so those kinds of.
All right. So when do you want this call back?
That's the question.
Sure.
So you don't have me remanded without bond?
Okay, so
understand.
here's the thing. You need to talk to your attorney
Yeah,
about
let-
that,
let's-
because I've explained it.
I mean,
All right, so
You have been
how much
informed.
time are you asking for to bring this back?
Just a week, Judge.
All right, Ms. Fergus, can you recall this in 1 week, please?
Yes.
And here you are.
Thank you. I am actually supposed to be here for sentencing on Thursday. So if
Okay.
I was planning to step away if we were in trial.
All right,
Like
Norma,
that.
if we can bring this back on Thursday? All right, we'll be back on the 30th.
Thank you, Judge.
And now you have that document, so now you know the bondsman needs to file a affidavit asking to restore your bond.
We'll address it then. Thank you, Judge, for your time.
You're welcome.